Let's get started with the calendar. Sorry to let you in a little bit late. There was an issue in lockup, not on this floor, that required Deputy Gordon and his team's attention. So we have a calendar that has some final pleas and looks like a few probation revocations. And I think at some point this afternoon, we're doing Mr. Robinson's case. Is that right?
Yes, Judge.
Oh, all right. For those of you who are here for final plea, this is the day if you're going to be resolving your case short of trial, where you have the opportunity to withdraw your plea if the sentence you get is more severe than what you asked for. But it may be you're not interested in the state's offer, and that's fine too. We'll just make a record of that. Yeah, my microphone is off. I don't know how to make it turn on right now. Oop, how about that? Is that better? It just went on.
That is better.
Woohoo! All right. Well, I just assigned all the cases to Ms. Willingham. That was what I was saying before, now that the microphone is working. So we'll work through the final pleas, and then we will turn to the probation revocations. Our first position is Ms. Hightower. Is Ms. Hightower here? How you doing? Good to see you. And Ms. Clowney is on. Let me. Hey, how are you? Let me. Good. There we go. There's Ms. Clowney. Ms. Hightower, why don't you come on up to the podium, please? And then Mr. Peoples, I'm not seeing. Ms. Willingham, oh, there he is. Are you going to be virtual today, Mr. Peoples?
Yes, Your Honor, I am.
Okay, great. So we've got the prosecutor, we've got Ms. Clowney, who represents Ms. Hightower, and we're on for final plea. I know there was an effort, Ms. Hightower, to get you into the diversion program, but I think the diversion program said no, if I'm remembering. Did you say no to them, or did they say no to you?
No, they didn't say no. I go to my orientation on Monday.
Oh, you're going to do diversion?
Mm-hmm.
Okay, why doesn't someone get me up to speed? That's not what I thought was happening. Mr. Peoples, what's your understanding?
Your Honor, I literally just got an email from Ms. Henry that this case, that Ms. Hightower isn't going to be accepted into this program. So I'm not sure what her understanding is.
So I got news long ago. It's on a published calendar that was published a while ago. And so it may have been Mr. Jordan who shared it rather than you, but someone had let my staff know that the DA's diversion program had said no to Ms. Hightower. And I'm pretty sure that Ms. Hightower's lawyers were copied on that. So I bet Ms. Hightower is real confused right now as to what's going on. Mr. Peoples, why don't you forward that email to me and to Ms. Clowney?
Okay.
And Ms. Clowney, tell me what you understood the situation was for Ms. Hightower.
My understanding is the same as yours, Your Honor, but I have not spoken to my client prior to this current hearing, so I don't know what notice she might have received indicating that she can begin on Monday.
Okay, so keep going. I'm sorry.
Oh, no, you're fine. I was just going to say I did speak with ADA Peoples, and we discussed a potential offer that I haven't been able to speak with her about as well this afternoon.
So why don't we do this then? What I'm going to do, you have a phone with you?
Mm-hmm.
Great. I'm going to ask Ms. Hightower to give you a call, Ms. Clowney.
Okay.
So the two of you can talk. So Ms. Hightower is brought up to speed, and you can share with Ms. Hightower what you and Mr. Peoples have been discussing. It may be we can still resolve the case today while Ms. Hightower has her final plea rights. But this case has been rattling around for a long time. So if we don't resolve it today, I do want to get it on a trial calendar ASAP. I'm not suggesting anyone wants it to go to trial. It may be that there's another way to resolve it, but it's ping-ponged around a little bit too much. So the email I am just getting.
I'm sorry.
No, why don't you tell me why you think you were starting on Monday?
I spoke, when I was released from Fulton County, they assigned me a probation officer, Ms. Turnbow. at pretrial.
Yeah,
And so I wasn't notified in June when the orientation. So she called me that day and was like, you missed your orientation. We rescheduled you for the 10th of July to
Sure.
start your classes.
oh, but that's for pretrial, not the diversion program. Got it. So you may well need to show up on the 10th to do something, but that is,
But I thought this was for the classes.
so give me the name again of the person you were talking to.
Miss Turnbull,
Do you know how to spell that?
I just spelled it Turnbull.
It's TURNBOW. She's in pretrial.
Okay, yeah, so pretrial is like probation, but it's not part of your sentence. It is something that a judge sets to be more comfortable that while you're on bond, you'll come back to court, you'll stay out of trouble, those kinds of things. And there may well be courses you can do while you're on pretrial that when it comes time to resolve your case, you and your lawyer can say, well, look how well Ms. Hightower's been doing. She's working, stayed out of trouble, showed up for court, and she took these classes. That is different from this diversion program that the district attorney's office runs. And that's what Ms. Clowney and Mr. Howard had been lobbying for on your behalf. And I think you were actually in it at some point way back when.
Right, I was.
And it didn't work out.
I paid my down payment and I did not hear from Miss Dawn and Miss Terry that was over that program again.
Right. And I think that pretrial diversion was one that is a third-party vendor, not the district attorney's office. So it's like second chance, or it's got a name. Since that time, the district attorney's office has established its own diversion program. And Ms. Clowney got you applied to that, or you applied to it, but you guys applied. And a while ago, the district attorney's office determined that wasn't going to work out. The email that Mr. Peoples got was a resend of it. And the reasons were you have some state court convictions, you've violated probation before, et cetera. And they have declined, which is their right. I mean, it's their decision whether to let someone in or not. That's not the end of the discussion, though. So what I'm going to have you do is call Ms. Clowney. We know she's available because she's sitting at her desk. Do you have a good phone number for her, or should we get it right now?
I can take it now.
Okay, Ms. Clowney, what number should Ms. Hightower call?
678-310-3476. And I also called her earlier from my direct phone number on my cell.
Okay, so you've got two different ways you ought to be able to reach Ms. Clowney. Give her a call. You can step outside to do that, but don't leave the building, because after you talk with her, the three of us need to talk again about what we're doing next in your case, okay? All right. So Ms. Clowney, you're welcome you can mute on this or drop off, but make sure you plug back in after you and Ms. Hightower have had a discussion, okay?
Yes, Your Honor, thank you.
Thank you.
You're welcome.
All right, position 2 has been reset. Is Ms. McBurrows here? Just in case she showed up. Mr. Peoples, we reset that. Ms. Mignot has a conflict. She had to leave or whatever it is. It was on the record. So I don't know what the new date is, but we'll do the final plea again soon for Ms. McBurrows.
Understood. Thank you, Your Honor.
All right. So that gets us to Anthony Harris. Anthony Harris is here. He's got 2 cases. Ms. Wood, what are we doing with Mr. Harris?
Judge, we can, I'm actually going to be asking for a reset. I received discovery on June 22nd. I think I will be filing a motion to suppress on the position 3.
Okay.
And I realize that it's not timely at this point, Judge.
Well, but if discovery came late, then it's not, the lateness is discovery as opposed to your motion. What about position 4?
So that one, Judge, has 2 co-defendants, but I think we could move forward on that one.
Let me
Oh, well, they might both.
They're both on judicial hold.
In the wind.
Yeah, so I'm not saying we need to work through it today, other than we can handle the final plea piece. I was assuming if it was going to resolve today, it would be a global resolution. But so more to the point, I was asking, do you have I didn't say these words though. Do you have discovery, and are there going to be motions in that case? Because we ought to then have one hearing at which the state puts up whatever evidence it has in connection with all your motions.
Yes, Judge. So I have not identified any potential motion for that case.
So we can pause that case, work through a motion to suppress on position 3. And once that's been resolved, put both these back on for final plea.
Yes, Judge.
Okay. Mr. Harris, do you follow what we were talking about? Do you have any questions?
I'm just trying to see, when this court date is gonna be like, because I might have to be working, like I'm trying to do, like, I need to take off or.
How did you learn about today's court date?
Yeah, I got a letter in the mail.
Good. Okay. Let me check, make sure we've got a good address. But that letter should have come not just yesterday, but a while ago.
It came like, maybe, I said maybe 3-4 days ago.
Okay. So you were able to plan a little bit to be here?
Man, I was gonna plan a little bit.
Good. You will get a letter for the next time you come here. It'll be for a motion. It sounds like Ms. Wood is going to file a motion. She has looked at the police report or maybe body cam or something from one of your cases and thinks that maybe there were some steps the police took that they shouldn't have, or they skipped some steps, something that she thinks might be a basis for me to rule that it sounds, I don't want you to admit to anything, but it sounds like you got arrested and you had cocaine on you. And it was a fair amount because it's with intent to distribute. And Ms. Wood thinks that there may be reasons that would support an argument that the police shouldn't have been messing with you on that day or in the way that they did. You'll need to be here for that motion. So that'll be the next time you come here. I don't know what that date is, but you'll get something in the mail just like you did. You still on Athens Avenue? Okay. If you move, make sure you let Ms. Wood know because that's the only way we can update your address. If you move and don't tell us, a letter is going to go to that address. And if you're not here when we have that hearing, then I have to sign a warrant that says, oh, Mr. Harris isn't coming to court. You've got 2 cases. So your ice is a little thinner than some folks. I'm not quite sure how you managed to get bond on your second case if you were out on bond when the first case happened. And it could be funky dates. It could be that one case is real old and then the new one came and you actually got a bond on the newer one first. I'm not going to change anything right now other than to make it real clear to you that if there are any hiccups, someone who's on bond for 2 cases, I'm likely to say your bond has gone away. And then you don't need to worry about when you come to court next because you won't be working. You'll be stuck. So keep doing whatever you've been doing, staying out of trouble more recently. And I think we will just set this down for a motions hearing.
Thank you, Judge.
So you have not yet filed the motion. You will be filing the
I will
motion.
be filing, Judge.
All right. Mr. Peoples, anything you want to add as to these 2 cases?
No, Your Honor. No, Your Honor.
Any reason you can share with me as to why Ms. Wood would have received discovery in a 2022 indictment a couple weeks ago?
I'll check, Your Honor, as the files come to me. I try to push out discovery as quickly as possible, but I will double check why it would have come late. But as they come, we work them up to be served for discovery and then push them out to our legal assistant who then serves it. But I will check, Your Honor.
I see why this would have had that kind of hiccup. The case that Ms. Wood is talking about came from non-complex. So you would not, you or more importantly, Mr. Jordan, wouldn't have had this all along. It didn't get bounced to us until just like a month and a half ago or so. It was the new case. I really need to understand how he got a bond on the new case. Or maybe that got transferred from non-complex as well. Did both of these? It lists both as, why are we getting this?
think it may be a repeat offender.
Someone must be a repeat offender. Okay, so you should make sure you've got discovery in both cases, Ms. Wood, because these are new. Now I'm getting it why it's new to you, Mr. Peoples. It's new to all of us, thanks to, okay, so it says Mr. Harris is a repeat offender. I don't know why they didn't figure that out with the 2022, but such is life. So, we'll see you soon. I don't have a date yet. It'll be to argue the motion to suppress the drugs in the older of the two cases. Anything else, Ms. Wood?
No, Your Honor, thank you.
All right. Any other questions, Mr. Harris? Okay, Mr. Peoples, anything else?
Nothing further, Your Honor.
All right. Thank you. All right, how about Octavius Price? Mr. Price is here. We've got Ms. Willingham online and we have Ms. Wood. Ms. Wood, let me switch our prosecutors here. All right. Oh, all right. Hey, Ms. Willingham, how are you?
Hi, Judge. My apologies for my casual attire, but I felt bad. Mr. Peoples has been covering for me all week, so I figured I would log on myself today.
Not a problem, and no need to apologize. Appreciate you taking time out of an important break you're taking to join us. So, Ms. Wood, are we resolving Mr. Price's case today?
Judge, if I may speak with him after the call of calendar, I'm going to see if we can resolve this today.
Okay. Ms. Willingham, are you with us for the hour plus that we'll be doing this or?
Yes, Judge, I'll be here.
Okay, great. So Mr. Price, if you'll take a seat, it may be that Ms. Wood has some new information she wants to talk to you about. And we're going to talk again regardless. If you've worked the case out, it'll be a longer conversation. If you haven't, we still need to get a few things on the record.
Okay.
All right.
Would it be a problem if I go back to my car and maybe put some more time on my parking?
It would not be a problem. I don't want your car to get towed or you to get a ticket. So if you want to go do that now, just make sure you come back. Because if we don't have that second conversation, then I really know what I'll do. I'll say bench warrant for Mr. Price. So but I know you'll come back. So go take care of the car and then get with Ms. Wood.
Okay, thank you.
All right. Quintavious Tullis, and I apologize if I mispronounce your last name. How do you say your last name? Tullis. All right, and that is Ms. Willingham and Ms. Wood. Ms. Wood, are we resolving Mr. Tullis's case today?
Yes, Judge, he's been offered and I believe accepted into the adult diversion program. I just want to go over the conditions before he leaves to make sure we're on the same page.
Okay, and this would be the district attorney's program.
Yes, Judge.
Is that your understanding, Ms. Willingham?
Yes, Judge. And once I confirm that he's accepted, then I will get a order over to the court.
So when you say confirm that he's accepted, meaning you don't have the green light from that team?
No, I do. I just need confirmation from Ms. Wood that he's going to actually participate in it.
Got it. It takes two, and the DA's office has said yes. Mr. Tullis needs to say yes, and that's what Ms. Wood wants to talk to Mr. Tullis about. All right, Mr. Tullis, do you need to go put money in your meter?
No, sir.
No, sir. All right, take a seat. Ms. Wood will talk with you. Jackson Dupree.
Kevin Conner here for Mr. Chopra on that matter. Mr. Chopra, I guess, received some additional discovery yesterday. The state's been very responsive. They will be filing a particularized motion to suppress based on that. Would like time just to properly pursue it. And we're requesting that it be continued to a further final calendar, Judge.
Do you know where Mr. Dupree is?
I'd like to think he's with us in spirits. I don't know, Judge. I could see what I can find out.
Okay, I'll give you a little time to try to track him down. He can appear virtually. That's okay. But I need to see him and hear him, or I will be directing Mr. Peoples' team to send us a bench warrant He's got a very low bond for a trafficking case and a gun case. So he needs to be here either in person or online. Assuming Mr. Dupree makes an appearance, what I understood you to be asking for, and you are affiliated with Mr. Chopra.
Yes, Your Honor.
Okay. You are saying, gosh, there's some discovery we just got, and we're going to file a motion to suppress.
Correct, Judge.
What is that discovery you just got?
That I don't know for certain.
That's something that Mr. Chopra said he just got.
Correct, Judge.
Mr. Peoples, was there anything you just sent, or what's happening here?
Yes, Your Honor, it was updated discovery. We had requested some additional information from the agency, which we received about a day or two ago now. And so it was updated and sent yesterday.
Got it. And tell me in just general terms, what kind of information would that be such that there could be a motion to suppress based on that?
My recollection, Your Honor, and I hope I'm not mixing this with a different case on the top of my mind. My recollection is that there's body cam in the updated discovery as well. But it's either body cam or dash cam. So that may trigger something.
Got it. Okay. What is a reasonable amount of time, Mr. Connor, to give Mr. Chopra to particularize that motion and file it?
I think a month's time would be more than sufficient, Judge.
Okay. How about 2 weeks?
You say 2 weeks? We'll have it done in 2 weeks, Judge.
Okay. All right. I don't have a specific date in mind, but it's probably not going to be a month to particularize a motion to suppress. But what we will do is continue this because of the newly provided discovery. And it's going to be a two-step process. The next time, and this is all contingent on you getting Mr. Dupree to show up, but assuming he shows up, then we'll see him and you or Mr. Chopra or someone from the defense side for a motions hearing. That'll probably be a month out. After that, you all can digest the result of the motion. That may affect what the state chooses to do. It may affect what the defense chooses to do, but we'd set it down for another final plea so that everyone has more complete information.
Your Honor, Mr. Dupree's right here, sir.
Where would that be?
I'm trying to figure out this camera on the phone. Hang on 1 second. I'm on Zoom. Hang on 1 second, sir. I just unmuted it.
Are you Mr. Dupree?
Yes, sir.
Oh, okay. You've been on for a while. The thing that says Tammy's iPhone.
Yeah, yes, sir. It's my mom's.
Okay. You are Jackson Walker Dupree.
Yes, sir.
Excellent. Well, thank you. You've been on the whole time then. I just didn't know Tammy meant you. Got it.
Yes, sir. That's my mom.
I hear you. Okay. So you've been following what we've said. Do you have any questions about that process?
No, sir.
Okay. So your lawyer just got some more information. He's going to digest that a little bit more, but he believes based on that information that there is a viable motion to suppress. He's going to file that, and then I'll need you to be actually here in person for that motions hearing along with Mr. Chopra or a lawyer who works with him so that we can have that hearing. I just don't know what that date is. Okay.
Is the hearing when I get sentenced or?
No. You'd have to plead guilty if you're going to be sentenced. And right now you haven't done that. You've pled not guilty. And what the hearing is a chance for Mr. Chopra to point out to me ways in which maybe the police did some things they should not have done, or maybe they forgot to do something or neglected to do something in order to either get a statement from you or seize some property. I don't know any of the facts about the case. I'll learn a whole lot more at that hearing. But Mr. Chopra will need you to be there as well, because it will likely be officers talking about whatever they were doing when they encountered you, and your lawyer is going to want you there to say like, oh, that's ridiculous. Ask him about this. Are you local?
I'm in Dallas.
Dallas, Georgia, or Dallas,
Yes,
Texas?
Dallas, Georgia.
Okay, that's local enough. You'll be able to make it to court. But you'll get notice, and Mr. Chopra will be reaching out to you as to when you need to come to court. Let me make sure we've got the right address in the system. Whoops, I just made you go away. Let's see. So I actually have an address in Rockmart for you. Is that correct?
Yes, sir.
On,
Yes, sir.
on
1388 Browning Road.
perfect. Yep. I guess Rockmart is near Dallas.
Yes, sir.
Okay, good. Then we've got a good address. You'll get something in the mail telling you when we're having that motion. I'll get either an email or an order out, Mr. Connor, that lets Mr. Chopra know, here's your deadline for perfecting that motion. And assuming you do by date X, then here's your motions hearing. If the motion is not perfected and filed by that date X, then we'll skip the motions hearing and just get this on another final plea.
Thank you, Judge. If we may be excused.
In a moment. Mr. Peoples, anything else on behalf of the state?
No, Your Honor.
Okay. Mr. Dupree, do you have any questions?
No, sir.
All right, then you and Mr. Connor are free to go.
All right. Thank you, sir.
Thank you, Judge.
You're welcome.
I'm trying to get off here. I don't know how. I don't know how to work this shit.
It's still
Excuse my
on, so
language,
you know.
sir.
Yeah.
My bad.
Okay.
I'm sorry, sir.
I'm gonna mute you. All right, I'll make your life easier. At least he had clothes on. All right, we've got one more final plea, and that is Francisco Arias. And I think I've seen Mr. Ghazi on. We've got Mr. Arias here. Hello, sir. Mr. Ghazi, are you on? Well, Mr. Peoples.
Your Honor, can you hear me?
Yeah, yes, I can.
Okay, I am here. Can you see me?
Yes, and I'm going to make it easier for everyone. There you are. Okay, and Mr. Arias, if you'll come up to the podium, we'll add you so you and your lawyer can see each other, and then we'll get Mr. Peoples in the mix. Look at that little family. Okay. Mr. Ghazi, I needed to see Mr. Arias, which I see now. I know you've asked for a reset. And I just want to talk a little bit about why we need it and to make sure, because I'll probably grant it, that when we meet again, you're not going to tell me, oh, but I also don't have any discovery. So since we're all together, I want to hear from you, Mr. Ghazi, if there are any discovery issues you're aware of.
Your Honor, Mr. Arias, roughly 2 weeks ago, 10 days ago, was released from custody of DOC. So he was in custody. While he was in custody, he has a couple other cases pending in other jurisdictions. Gwinnett County, Habersham County. I had backburnered these. So I am trying to get up to speed now with my schedule. And I apologize. I believe my secretary in my office told me that we do have some discovery in this case on Arias that recently came in, but I haven't had a chance and opportunity to get to that. I would ask for as much time as Your Honor can grant before we set another final plea date. And by that point, we'll be up to speed. And if there's a suppression issue or some other motion that needs to be filed, we can be ready, or we can be in discussion with the state about a resolution. But given the fact that Frankie has just gotten out of prison, we're just kind of trying to get up to speed on these cases.
Okay. Mr. Peoples, I see in the docket that you did just provide some additional discovery. And it may not be additional. It may be the first time discovery was served because it includes the indictment. How was this served? Is it a evidence.com link or do you know? Mr. Peoples, you're on mute.
Sorry, Your Honor. I was saying I'm checking right now, Your Honor, and I believe it is through an evidence.com link because I'm seeing the certificate of discovery, which includes videos, and those would be sent all through evidence.com.
Okay, so Mr. Ghazi, I need to make sure that you or your staff go to that link ASAP and download the files, because those links have a tendency to expire. And what I don't want to have happen is that I give you a little bit of time to get current on a case that is not current. This is not a new case. Mr. Arias was arrested in 2021, indicted in 2022, and here we are in 2023. So I'm going to want it to continue to move forward. But what I don't want to have happen when we next meet is for you to tell me, oh, they sent discovery, but the link has expired. So your number one project is to make sure that someone pulls down all that discovery, including the videos, from the evidence.com website. Can you do that?
Your Honor, I believe that my office has done that already, that she had communicated that to me, that she had done that. But what I can let the court know is that if there's a problem with us receiving that, and occasionally there is with this technology, depending on who it's sent through and that type of information. But if I have a problem with it, if you reset it, I can get with Mr. Peoples by next week, or by the middle of the week, I would say, as soon as he's available. If there's a problem, I'll call her today to make sure. And if there is a problem, then we'll be on it immediately, or else I'll be back in touch with the court within 10 days to say that, we have made this. We were actually not able to open what we had. We don't have it all. And we have, at this point, a week out or 10 days out, we have not been able to get updated from the state yet. But if Your Honor wants to proceed that way, or if Your Honor would want me, it's entirely up to you. I can log off, I can call my office, and I can see what the status of that is right at this point.
No, I will. Well, sure. I'll take you up on that offer because we'll be on for a little while longer with some other matters. So you could just confirm that your office was able to download all that. Mr. Peoples, I'm confused. This is one where the scheduling order went out in March. So it's pre Mr. Peoples, but a scheduling order went out in March saying, hey, you've got to provide discovery. And discovery went out in July. So are there going to be a bunch of other cases that have fallen through the cracks, or what's a good way for us to make sure that you are picking up where maybe Mr. Jordan didn't quite manage to close the loop?
Your Honor, I know Attorney Jordan was very diligent about, discovery and making sure that it was a smooth transition. I don't imagine that there are many. I know that, everyone's not perfect, so there may be one or two, but I don't imagine that there are many that would have been like this.
Okay, well, we happen to have two on one calendar, so I'm going to trust you on that one, but the numbers aren't running real well for you right now because this is the second case on this calendar where discovery seems to have popped out a little bit late. But I'll get with Ms. Nelson and we may enter a revised scheduling order in light of the recent provision of discovery that gives Mr. Ghazi some time, which he's entitled to digest the discovery, particularize any motions, and then we'll have a motions hearing date. We won't need it if no motions are filed, and it will have a new final plea date. So Mr. Ghazi, I won't keep Mr. Arias here. He'll be okay to go. And if you would please pop back on, and when I see you back on, I'll pause whatever we're doing and you can confirm that it was good news or, the link didn't work.
Will do, Your Honor. I'll do that right now.
All right. Before you go, Mr. Arias, do you have any questions about what we've been discussing?
Yeah, I actually want to make a correction to what Mr. Ghazi said, right? Clive actually closed the cases that he mentioned. They're all closed, they're dismissed, and I'm not on probation or anything like that anymore, so.
Is that why you got locked up? Was it a probation revocation or?
For these charges.
So because you caught these charges, you got revoked in other places?
Yeah, but I completely finished everything. Like there's no more probation, no more parole, nothing like that.
Okay. So what you've got is this case?
Yes, sir.
All right. Well, that's good because I was looking at your bond that you got a long time ago and I'm like, wait a minute, you're Habersham County in this county, maybe bond is not a great idea. But if this is all you've got, then we'll maintain the status quo. And I've got an address on Shallowford Road.
Yes, sir.
That's still good?
Yes, sir.
Okay, that's how you'll get notice. You don't need to stick around. I'll hear back from Mr. Ghazi in just a little bit about discovery, and then we'll get this new scheduling order out. Okay?
Thank you, Your Honor.
All right. Mr. Ghazi, anything else while your client's here?
Just one quick question. Just call me, Frankie, and we'll talk later.
Yes.
Okay. All right. Thank you.
I'll be back, Your Honor.
Good.
Okay.
All right. You're good to go.
Thank you, Your Honor.
All right. Let's circle back before we get to our inquiry. Ms. Hightower, did you and Ms. Clowney have a chance to speak? Okay. Ms. Clowney is back. Let me add her to the spotlight. Ms. Clowney, we still have to have a conversation one way or the other. So why don't you come to the podium? I'll add that back. There we go. And why don't we figure out where we're going next? Did you, Ms. Clowney, need to speak with Mr. Peoples, or have you all been emailing or texting, or are we good?
A little bit of both, Your Honor. We're good.
Okay. All right. So Ms. Clowney, are we moving forward today to resolve the case, or should we move Ms. Hightower's case to a trial calendar?
Yes, we're going to resolve today with the plea.
Okay. We'll do that in just a moment. I want to see what we're doing just so we can schedule things. How about Mr. Price? Ms. Wood, you need to speak with Mr. Price. He's back. He put money in the meter.
I do, Judge. I didn't know if you want me to make my announcements on positions 9 and 10 before I did that.
We'll get there in a second.
Okay.
So you still need to talk with Mr. Price,
I do, Judge.
and you want to talk with Mr. Toulis.
Yes, sir.
All right. And you can do that during the plea because that doesn't involve you.
Yes, sir.
Let's talk about Mr. Harris, who is here. Mr. Dunning, we've returned. He was inadvertently brought over, but the plan wasn't to have Mr. Dunning come out here.
Yes. Okay, Judge. That's fine. Do you want my announcement on Mr. Harris?
Yes.
I need some direction from the court on this one. There was an order committing him to DBHDD that was, I thought Ms. Primovic had submitted it in April of this year, but now I'm looking at the docket. It's not actually filed.
Uh-oh, okay.
But I had talked to Dr. Schwenke about it in May, and she was going to get me an update, and then I was out of town. And I left her a message earlier this week and haven't heard back. Should I just refile the order?
Why don't you? It may have been that I dropped the ball. And we can also check with Ms. Green, who tracks all those things, but there ought to be something in the docket. And it might just say order if I did it. So if you don't see anything in there, it could be that, let me do two things. Look for that and, excuse me. The only email I still have from Ms. Primovic has to do with Daryl Lowe, and we're not talking about that right now. So let's see the docket. Nope, it's just been inquiry calendars. So if you would send something in Word format, and that's based on work that was already done and a professional opinion that that's the direction Mr. Harris needs to go in.
Yes, Judge. The last evaluation that came back from them, and that was the word, was in like the very end of October last fall.
Okay, then what's Dr. Schwenke doing? Did she do a subsequent evaluation, or has Mr. Harris been in the restoration space?
So that's what I was trying to follow up with her about, because I thought if the order was submitted in April, like I thought it was, I was under the impression that we were nearing the 90-day, and it wasn't clear if he was actually in the restoration unit or still awaiting a bed at DBHDD.
Okay. So Ms. Sellers reached out in May and said, why aren't you doing something in a very nice way? Why don't you do something? And Ms. Nelson had forwarded that to me, and I didn't do anything. I did do something, but that was in November of 21. I did an order.
So he's one of my ones, Judge, who has been incompetent and then restored and then.
Oh, and then decompensated again. And
Yes.
so the thinking is he needs to, okay, so I have, but I want to be clear, I'm not counting this as what Ms. Primovic, because this was before Thanksgiving in 21.
Yes, Judge.
So he needs to go back.
Yes, there's a more recent one.
Okay, if you would, I know there's a more recent report, and that's what was causing Ms. Sellers to reach out to say, what are we doing here? So if you could send a proposed order, I will prioritize that. I'm
Send it right now, Judge.
writing it in red.
Thank you.
Okay, and how about Mr. Dunning?
Judge, this is the one I believe we were communicating via email on Mr. Dunning last week, if you recall. This is one where Dr. Schwenke says he's very close. They're still working with his medication.
Right.
Just not there yet.
Okay, and so you basically gave us the inquiry update last week.
Yes. Judge.
And so 30 days out, and maybe do transport Mr. Dunning next time?
Yes, please.
Okay. So Dr. Schwenke was thinking that there could be restoration here, not having to send Mr. Dunning anywhere else.
Yes.
Okay. Got it. Okay. Done.
Thank you, Judge.
You're welcome. So let's turn to Ms. Hightower and make sure we've got Ms. Rivers ready to go. Ms. Rivers, have you able to hear us?
Yes, I am, Judge. I'm ready.
Great. Happy Friday.
Happy Friday to you.
You missed Roscoe. He missed you.
Oh, next time.
Yep. Okay. This is position 1 on our final plea calendar, State versus, you pronounce your first name? Lewan Hightower, Ms. Hightower, 19 SC 167523. Ms. Hightower is here in court. Her lawyer, Ms. Clowney, is appearing virtually, and Mr. Peoples is the prosecutor. Ms. Hightower, my understanding is that you're prepared to go forward with a plea in your case. I want to make sure that you are comfortable doing that with Ms. Clowney being remote from you. You can say, nope, I'll only do it with my lawyer by my side, or you can say, I'll do this, knowing that if you ever need to speak with her privately, we'll take a time out. You can go into the jury room or out there and call and speak to her privately. If we work it that way, are you comfortable going forward? You guys say out loud. Yes. Okay. You're ready to get this over with. Also, yes. Okay. It'll be important as we go through this, that whatever your answer is to the questions you get, that you verbalize them. The court reporter can't take down, she nodded yes, or something like that. So yes, no, I don't understand, 17, whatever your answer is, make sure you verbalize it. Okay. All right. And you verbalize it like you're using an outside voice. Okay. All right. In a moment, Mr. Peoples is going to put you under oath. Once you're under oath, you'll need to answer all his questions truthfully. If at any point there's something that confuses you or it's not going the way you thought it was going, like a whole lot in this case, I need you to tell me that and say, wait a minute, I'm confused. I'll try to answer your question. If I get the sense that you and Ms. Clowney should speak privately, we'll make that happen and you guys can have a private conversation. None of this is meant to be tricky or confusing, but sometimes lawyers use big words and that's not how I might say it, but it's how the lawyer may need to say it. And so if there's something you don't get, I need you to tell me that, okay? All right, before we start, I see that Mr. Ghazi is back, so we're going to go off the record. Mr. Ghazi, what do you have to tell us?
Your Honor, I appear to have all the discovery, all of the printed discovery I appear to have, and I do have a video link as well. So if there's anything that I am missing, I will contact Mr. Peoples, but I believe that I'm up to date on the discovery and ready for a reset date.
Fantastic. We'll do that. You have a good weekend, sir.
Very good, Your Honor. And we'll get that in the mail?
You will get it e-filed. The scheduling order, you'll either get an email from me directly, or Ms. Nelson is going to file something, setting some new dates, okay?
Very good, Your Honor. Thank you.
All right, take care.
Okay.
All right, Mr. Peoples, you are up.
Thank you, Your Honor. Ms. Hightower, are you able to hear me?
Yes,
Will you raise your right hand? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
yes.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
My first name is Laywan Hightower.
And we'll need you to spell the first name for the record.
Spell it. The first name, Laywan, is Leijuan. Last name, Hightower.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No,
Is there a medication that you normally take that you have not been given today?
no.
How old are you?
I'm 38.
And what is the highest level of education that you've completed?
High school.
Do you have are you able to read, write, and fully understand the English language?
Yes,
He has to ask that question. He's not picking on you.
Do you understand that you're charged with the following offenses? Financial identity fraud, which carries a sentence range of 1 to 10 years. Deposit account fraud, $1,500 or more, which carries a sentence range of 1 to 3 years. Forgery in the third degree, which carries a sentence range of 1 to 5 years. And theft by taking, which carries a sentence range of 1 to 5 years. Do you understand that?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges?
yes,
You understand that that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
yes,
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
You need any more time to discuss with your attorney?
no,
Are you satisfied with their services?
yes,
Counsel, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment, including any with respect to your client's name?
yes, I do.
Ms. Hightower, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, we'll be asking for 2 years probation and restitution in the amount of $2,200 to Robert and Nancy Myers, who are the victims in this case. I believe that defense will be asking for first offender in this case.
Okay.
You understand, however, that the court does not have to accept this recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
yes,
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty.
yes,
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
yes,
You understand that you are not allowed to possess nor use a firearm while on probation.
yes,
Are you a citizen of the United States?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal a convicted of these charges after a trial. You understand all these rights?
yes,
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
yes,
How do you plead to count 1 in the indictment of financial identity fraud?
guilty,
Count 3, deposit account fraud, $1,500 or more.
Guilty.
Count 8, forgery in the 3rd degree.
Guilty.
And count 16, theft by taking.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction.
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on September 12th of 2018, at 4722 Jonesboro Road in Union City in Fulton County, law enforcement responded to a theft from a vehicle incident. They met with the victims, Robert, common spelling, and Nancy, common spelling, Myers, Myers. Mr. Myers stated that he and his wife had exited a furniture store and their vehicle had been broken into. Mrs. Myers' purse was inside of the vehicle and had been taken, and there was about $2,200 in cash that they were going to be using to buy furniture. There were also debit cards and Social Security cards in there as well. A witness on the scene, a witness who was no longer on the scene at the time, told the Myers that they'd seen a black male subject with dark jeans leaning inside the passenger side window of the vehicle and then left the location in a Dodge Charger. Detectives later spoke with Mrs. Myers, who stated that her checkbook had been attempted to be used. And Mrs. Myers stated that some of the checks were used. Robert and Nancy Myers' names were forged on the checks. This is a co-defendant case, Your Honor, and they were able to be identified because the activities associated with the stolen checks that were deposited into the respective co-defendants and the defendants' accounts. Counsel, do you stipulate there's a factual basis for this plea?
Yes, I do.
Thank you. And Your Honor, would you like for me to address the first offender part of the colloquy?
No, I'll cover that.
Okay.
But I do have a question. So I think I follow the storyline here that you'd be presenting to the jury if this went to trial. So Ms. Hightower, it is alleged, and she's now admitted, she got one of those checks somehow from the Myerses, and in September of 2018, a long time ago, she wrote out one of those checks basically to herself, because what it says in count 3 is that, I guess that's the Wood Forest National Bank. Is that the bank of the Myerses, or that's the bank into which Ms. Hightower sought to deposit the check?
1 second, Your Honor.
It says drawn on, so that must be, that's the Myerses account. So their account was Wood Forest National Bank. And I guess that what Ms. Hightower is admitting she did was she had one of those checks, and for $1,500, she did something with that check, and that came out of the Myerses account. That's bad news for the Myerses.
Yes, Your Honor.
Okay, I think I follow that. So where is the $2,200 that you are suggesting Ms. Hightower owes as restitution would be the cash that at best you'd be able to show a black male would have taken out of their car, because that's who might have grabbed Mrs. Myers' purse?
Correct, Your Honor.
Okay, I follow all that. Thank you. Let's see. Do we have anyone from pretrial on? I don't
Yes,
think.
Judge, I'm here.
Oh,
Yes,
there you
I'm-
are. Great.
Yeah, I'm here.
How are you, Ms. Tyson?
I'm good. How you doing?
I'm well. Thanks for joining us. Tell me what you have for Ms. Hightower's criminal history.
I have 13 arrest cycles beginning in 2002. She has no felony convictions. She has 1 FTA and 7 violations of probation. They're all misdemeanor probation violations. It seems like most of them are out of Douglas County, and the underlying charge was a misdemeanor simple battery.
Oh, most of the violations are all from one case?
Let's see, let me go track through them. It looks like they're all Douglas County.
You get,
Let's see.
It's for child support.
oh, you
Yes.
get violation of probation for child support? That's how it was set up? Okay. It's not a big problem. I'm just trying to understand. It's a big number, what that was about. Okay. So, Ms. Tyson, how many misdemeanor convictions do you see?
We have a misdemeanor for false report of a crime. That was from 2002 in Douglas County. Let's see. We have a NOLO battery, simple battery, family violence out of Douglas County in 2007. Abandonment of dependent child from 2010 in Douglas County. And that is it. That's it.
Okay, so 2010 is the last one. So we're 13
Yes.
years past that. Okay,
Yep, 2010 was the.
got it. Thank you, Ms. Tyson.
And then the
All
last,
right.
and the last arrest was a violation of probation out of Douglas County.
Okay,
Mhm.
thank you.
You're welcome.
Ms. Clowney, what do you want to share about Ms. Hightower's situation?
Your Honor, I may have misheard or missed it, but I just wanted to clarify one of the terms of the offer that we agreed to, in being that we were requesting that 1 year be suspended upon the successful completion of full payment of the restitution amount. But she does not have any prior felony convictions. As you can tell, she's very emotional about this situation. She's taking it with the utmost sincerity. And this is something that she is looking forward to putting behind her. She is requesting that this be pled under the provisions of first offender, so that she can move forward at some point and nothing like this occur again in the future. So we are requesting that the court accept the plea as negotiated.
Okay, let me ask Ms. Tucson from probation a procedural question. Can I set a behavioral incentive date that is only a year out, or does it have to be 2 years or more out?
It is 2 years at a
Okay.
minimum.
Got it. Okay, thank you for sharing that. Ms. Hightower, you don't have to say anything if you don't want to, but you also get a chance to say, let me tell you what I think about this. If there's something that you want to share, you think I should know, it's not a problem to say nothing, but you get a chance to weigh in as well. I've got a couple questions if I could ask them first, and then if there's anything you want to add, you can. Tell me how you knew, if you did, Ms. Hart and Ms. Lett.
Ms. Hart?
So the co-defendants in this case are Letitia Hart and Lakeisha Monique Lett. Have you ever heard of those people? No? So how did you end up with the check in this case? And you don't need to name names. I'm not trying to out anyone. I'm just trying to figure out if you don't know the two of them, because Ms. Lett in particular, she had more of these checks. And so I assumed, clearly wrongly, that you knew one of them and they said, here's a check. Or often how these schemes work is, I'll give you $50 if you'll go cash this check. And you get $50 and you get arrested and someone else gets $1,500. And it's usually a bad deal for the person who had the check.
I didn't do nothing like that.
Okay. So tell me what you want to tell me. And you don't need to tell me anything more if you don't want to. But the police somehow connected you to all this. They didn't pick a name out of a hat.
What I was told when I first got arrested, because they came to my job, I was a store manager for Family Dogs since 2015. And they arrested me one night. We had just come back from vacation, and the police said that that's what I was being arrested for. And I hired Mr. Howard because I don't know what to, I can't have nothing like that on my record because
Sure.
I'm a store manager and I've never stole anything. I've never took nothing from anybody. So I hired an attorney because I don't know nothing about the law or anything. And this is my first time hearing from the DA about, the details of it, because it's been ongoing with Mr. Howard. And, we was going back in 2019, 2020. I think we came like one time before the pandemic came.
Right.
And I never kind of got the full story of what was going on. So I was like, I should be fine because I have an attorney, you know what I'm saying, to prove my innocence. And now we're here.
Okay. Well, let me talk to you about it a little bit more and we'll see where you fall on all this. But what you're telling me is you don't know Ms. Hart or Ms. Lett. If they were in here saying now we're pleading guilty or doing whatever, they'd be strangers to you.
I was at court in 2020. I know you said that I had co-defendants, and at the time I didn't know what the co-defendants was. So when we was leaving out, I asked Mr. Howard, and he told me it's like other people too.
Yeah. Okay. Do you live in Douglas County or you used to live in Douglas
I
County?
was married when I was younger with my ex-husband there.
Okay, so the case is out of Douglas County. You were living there.
Yes.
Okay.
With my ex-husband.
Understood. How many kids do you have?
3.
How old are they?
My oldest is 23, Lawrence. He's in the military. He goes to Clark, Atlanta. My daughter just turned 21 on the 16th of June. She goes to Georgia State. And then I have a 17-year-old, Caleb. He's still in school.
Where does he go to high school?
He's not in high school. He's in K through 12 online schooling.
Okay.
He lives with his dad. I've been going back and forth with trying to get custody of him.
Is his dad your ex-husband?
Yes.
Okay.
And to get him to come and live with me so he could kind of do better, get back in school and get on his feet.
Did he used to be in a standard school and something happened?
Mm-hmm.
And so now he has to do it virtually.
Mm-hmm.
Okay. Got it.
And I pay child support for him.
You pay child support.
Yes, because that's what the child abandonment was. My ex-husband was mad because I went through with the divorce and he filed a lot of child abandonment warrants on me. I didn't know.
Okay.
So
one kid at Clark, Atlanta, who's also in the military, one kid at Georgia State, and then your youngest is with his dad.
Mhm.
Okay. All right. Well, Ms. Hightower, I need to talk to you about first offender. Make sure you understand it because I think it's a good fit in your case. First offender is primarily an opportunity. If you successfully complete your sentence, and it sounds like you will, in this case, then first of all, it's not a conviction. If I accept your plea and sentence you as a first offender, when you leave here today and go out the door you came in, you're not leaving with a conviction. You're not a felon. You're on probation, but it's called first offender probation. So you'll need to make sure you comply and report and do the things you need to do. But it's not a conviction. And if you successfully complete your probation, then it's all wiped off your record. So it doesn't show up when someone runs criminal history. It's not a conviction. And if you successfully complete it, it's like it never happened. Of course, it did happen and you've gone to jail at least twice because of these charges. But in terms of it interfering with your ability to work or go back to school or whatever you want to do, the good news about first offender is that it has no impact on that. I'll answer your question in just a sec. I need you to understand the downside of it. And that is that if you don't do well on probation, you can have your first offender status revoked and I can resentence you. And some of these charges have some big windows, like the financial identity fraud. That's up to 10 years. And so just as a hypothetical, let's pretend if we're back together in 6 months and they found your purse stuffed with other people's checks, I'd probably resentence you as a felon because you would have been acting all boo-hoo with me. I don't know what this is about. I've never done it. And my ex-husband set me up. And actually, this was something you were doing all the time. And you would have deceived me and your lawyer and everyone else. And you'd have your new situation. And I would likely send you away for a while and take away your first offender status. I don't say that to spook you or threaten you, just so you understand how first offender can work poorly. It's generally an opportunity. And if you know that this isn't you and what was going on way back in 02 and 07, that was a different and not a healthy situation, and you're going to stay out of trouble, first offender is a great opportunity. Do you feel like you understand the benefit of first offender and the risk of first offender?
Mhm.
Yes?
Yes.
Do you have any questions about it? Because you did raise your hand, but I wanted to get through my little speech.
I do have a question.
About first offender or something else?
About the first offenders. So let's say if my current job wanted to put me in a higher position and they run my background, would that show up like?
It's not a conviction, so it wouldn't show up as a conviction. The arrest is still out there. It's not an open case anymore. So if they run your criminal history, it's a closed case with no conviction. Okay? So I'm not an employer. Employers sometimes do funny things, but that's where you could reach out to Ms. Clowney to say, I'm confused as to why this is an issue with an employer. But because it's not a conviction, normally what employers can get is very generic information. Does Ms. Hightower have any felony convictions? Answer is no, if I sentence you as a first offender. Does Ms. Clowney have any open felony cases? Answer is no. This case has been closed out because you will have been sentenced, but without a conviction. That's the whole point of first offender, is to protect for work or school or military. It would be trouble for your son if he picked up a felony conviction. It wouldn't be good at school. It would be curtains for the military. They'd say, you can be a mercenary, but you're not going to be in the military.
Mhm.
Okay. Did that answer your question?
Mhm.
Ms. Feely?
With the risk of not being in my lane, I would just say there is a way to just kind of make it cleaner, and that is an order to seal, which I'm happy to provide to Ms. Clowney or prepare if the court would consider signing that and while she's on probation.
Not only would I consider doing it, that's what happened to one of your co-defendants. If you try to open up, I guess it would be Ms. Lett. Hers on the screen here says confidential because she got first offender and her lawyer said, hey, could we do one of these orders to seal? So that's very gracious of Ms. Feely to offer that up. Ms. Clowney may have been ready to say that anyway, but regardless, Ms. Clowney and Ms. Feely can connect. Ms. Feely can send a sample order. She does them all the time when we've got first offender cases. And that adds an additional layer of protection. It doesn't change anything I said, but it's like another layer of wrapping over this situation. Okay.
Okay.
So I feel like you understand first offender. Do you have any other questions?
Yes.
Okay. Well, Ms. Hightower, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. I know that you're emotional about this and you're not happy about this, but I don't feel like anyone is forcing you to do this. You know your options. You could go to trial and run the risk of a felony conviction. Also could be found not guilty, but it could be a felony conviction. And you are choosing, after having had a chance to speak again with Ms. Clowney, to go forward with the plea. Is that correct?
Yes.
Okay. I'm sensing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a small problem, like maybe you miss one appointment with probation, They don't call me up and say, oh, you got to get her in court. But if you have a bigger problem, if you get arrested for something and really anything, that comes back to me and we'll work through it. Mr. Peoples, do you authorize me or my staff to sign the indictment on your behalf?
I do, Your Honor, and I was just going to ask is the court still going to grant the provision that if the restitution is paid, that probation will be suspended?
So I haven't gotten there yet. So it's a good question. I haven't forgotten that. All right, no problem. Ms. Clowney, may we sign the indictment for you?
Yes, Your Honor, thank you.
Okay, Ms. Hightower, is it okay if we sign the indictment for you?
Yes.
All right. So Ms. Hightower, I will sentence you as a first offender, and your sentence will be as follows. For counts 1, 3, 8, and 16, I will sentence you to 2 years, and those will all be 2 years of probation, and they'll all run concurrently with each other, meaning at the same time. So your sentence is 2 years probation. I am going to require you to pay $1,000 in restitution. And you don't need to worry about where that goes. Probation will figure out the contact information for the Myerses, but it'll be $1,000. You don't need to pay that up front. You will pay it as you are able, because it sounds like you have other obligations. And if you have paid all the restitution after you have been on probation for 1 year, then I will approve of any request by probation to suspend the balance of your probation. So you're getting the full 2 years to pay that off, because times are tough and it may be difficult to do that. If you pay it off in less than 1 year, when you hit that 1 year mark, so July of 2024, if everything else has been going well, you report when you need to report, you're not hard to find, you haven't been arrested for anything else, then probation can petition to me to suspend the rest of it. Does that make sense?
Yes.
Okay. Mr. Peoples, anything else for Ms. Hightower?
No, Your Honor, thank you.
Ms. Clowney, anything else on behalf of your client?
Just to confirm, Your Honor, so the restitution amount that she has to pay is $1,000, not the $2,200.
That is correct.
And her record will be sealed while she's doing her probationary period.
If you submit a proposed order to seal in Word format to Ms. Nelson, then she'll get that to me and I'll review it. I'll sign one, but I want to get it in Word format. And then Ms. Clowney, if you want to put in the chat, are you on? No. You're not on, but you could send it to me, your email address, or you can just say it over the call. Ms. Feely will send you her go-by. She just doesn't see an email address for you in the bar directory. Very secretive.
Okay. Okay, thank you.
All right, so hopefully she'll send that to me, and we'll work through that. The last thing we need to do, Ms. Hightower, is that Ms. Tucson, who's on this call, who works with probation, needs to get some contact information from you, and she's going to give you reporting instructions, because you will real soon, not today, but in the next few days, need to make contact with probation. Okay, Ms. Tucson?
Do I still report to Ms. Turnbow too? No.
Nope, and you will not be in trouble.
I'll let Ms. Turnbow know that she took a plea today. So I will let her know, and then we'll close out the pretrial case.
Excellent. Thank you, Ms. Tyson. So Ms. Tyson works with Ms. Turnbull.
Okay.
They are colleagues, and so she'll and this is natural. This is how it happens. If you plead, then pretrial steps out of the way and probation pops in, and that's Ms. Tucson. So Ms. Tucson, what do you need from Ms. Hightower?
Ms. Hightower, which county do you live in?
I live in Griffin, Georgia.
What county is that?
Spalding County.
Spalding?
Yes.
Okay. Well, I'm going to give you a report date of July 25th. I need your phone number so I can call you, and I got to double check. Some of the smaller counties don't have reporting offices. I'm going to look right now. What is your
I can stay with the reporting office up here, because I work up here at Atlanta Missionary. So I work there Wednesday through Saturday, so I'll be here those days.
Okay, would we be able to do that, Ms.
Okay.
Tucson, to let Ms.
Um,
Hightower have her initial report at least be here in the Fulton office?
Yes, we can do that, and then they'll let her know, depending upon the level of supervision, if she might just have contact reporting, and then they transfer it to that county. What's your phone number, Miss Hightower?
It's 470
Okay.
661
Uh-huh.
1224.
Okay, I will be calling you to confirm your address and double check that, but either way, you'll be reporting July 25th, whether it is here or whether it's out in that area. Like I said, some of those smaller offices, they don't have reporting, but I will call you to confirm that, okay?
Okay.
Anything else, Mr. Peoples?
No, Your Honor.
All right, Ms. Clowney, I've got your email address right here. I'm going to give it to Ms. Feely. You may want to let the state bar know it so that when people look you up, you'll get more business that way. If they have an email address, they can reach out to.
Thank you, Your Honor.
All right, you are free to go. And Ms. Hightower, good luck with everything, okay?
Thank you.
We've been working together on this for a while. So if I'm going to bump into you, it would be at, where do you work?
I work at Atlanta Missionary. It's the women's shelter.
So we're not
off
going to
of-
bump into each other.
Off the north side.
Got it.
I also work at, I got a second job at Marco's Pizza in Marietta, but that's in Marietta.
Oh, yeah, I don't make it out of, my kids play baseball over there a lot and they eat a lot of pizza. So maybe we'll see each other there. My guess is I won't be at your other place of work. Okay? Good luck with everything.
Thank you, Your Honor.
You could give this
Y'all
to
have a
us.
great day.
I think you can read my handwriting, but it's self-explanatory because it's basically your first name and then the firm. Before anyone changes their mind. All right. Thanks, Ms. Clowney. Have a good weekend.
Thank you all. You all have a great weekend as well.
All right. Should we do Mr. Price? Well, what are we doing with Mr. Trulis?
Judge, on Mr. Chulos, he is accepting diversion.
Okay.
I've sent the email to the appropriate parties with the DA's office. So I think that's all we do for now on that one.
Okay, let me make Mr. Peoples go away and in a gentle way, and then we'll get Ms. Willingham back. There we go. Mr. Tulis has been offered, this is the gentleman where I just misunderstood what Ms. Willingham said. So the DA's office said, yes, you're in if you want it. And he is saying, yes, I'll take it.
Correct, Judge.
Great. So that means then Ms. Willingham will send to Ms. Nelson the order that would place this on judicial hold during that time that Mr. Tulis is taking care of his obligations.
That's correct, Judge.
Okay. You follow all that, Mr. Tulis? So hopefully Ms. Wood has laid it out. It's usually some community service and a class and a vision board, and it's gonna be like you're back in school. You may have to write an essay, something like that, but it's a relatively low impact way to have charges like these go away. As long as you live up to your end of the bargain, the state is obligated to dismiss, throw away the case once that time arrives. And you don't have to come to court and see me in the interim. You'd only see me again if there's some part you dropped. Okay, any questions about that? Okay, do you need Mr. Tulis to stick around anymore?
No,
All right, well, we'll look for that order, Ms. Willingham, and that'll take care of Mr. Tulis's case for now.
thank you, Judge.
All right, and Mr. Price is going to be a plea? No,
Not a plea today, Judge.
okay,
So if we want to do the final.
we should. So why don't you have Mr. Price come sit with you and we'll get that on the record. All right, let's start with discovery. Hold on one second.
You're welcome.
Sorry, that was time sensitive. Okay, let's get on the record. This is 23 SC 186513, the final plea discussion in State versus Price. Mr. Price is here, seated with his lawyer, Ms. Wood. Ms. Willingham is connecting with us remotely for the state. Ms. Wood, do you have all the discovery you're aware of in this case?
We do, Judge.
No issues there, no motions coming in late?
No, Your Honor. We also have an offer, and I do think we'll have a non-trial resolution on this case. I'm fine with it going to a trial calendar. He's in the military, so we might get a creative solution going.
Okay. Well, let's get on the record what the offer is, and Mr. Price's no thank you for now. This case is on the September trial calendar, so there's a little bit longer window. It's not going to be on the August. You got a couple months to try to come up with that creative solution. Ms. Willingham, if Mr. Price were to plead today, would he be pleading to the charges as they are in the indictment, and what would the state's recommendation be?
Yes, Your Honor. If Mr. Price were to plead today, he would be pleading to the charges as indicted. As to count 1, it would be 3 years probation. As to count 2, it would be 12 months probation to run concurrent with count 1. And as to count 3, it would be 5 years suspended, and that would run consecutive to count 1. And Your Honor, I do believe Ms. Wood is correct. I think we will be able to get to a resolution, but she made a counter, and I need to be able to speak with the victim about it. So it's not something I am prepared to do today, but in my conversations with the victim, I do still think that it will be fine, but I'm not comfortable agreeing to it without having the conversation.
Got it. And what is the relationship between Mr. Price and the victim?
They have a child in common.
Got it. Okay. So, Mr. Price, if you were to enter a plea today, the recommendation from the state would be effectively 3 years probation. There'd be some more time that's suspended after that, but you don't report anywhere. There's just this sentence out there. It'd be a total of 8 years because the firearm count has to run consecutive. But the piece that has teeth, and they're small teeth because it's probation, not prison, is a 3-year probated sentence. Do you understand that that's what the state would recommend?
Yes, sir, I do.
Okay. Now, Ms. Wood might recommend something different. She could ask for less probation. She could not ask for less. Actually, count 1 is a range of 3 to 20. Is that right?
That is correct.
Okay. She actually couldn't, she could, I guess, ask for some additional suspended time. So maybe less probation than 3 years, but your sentence would have to be at least 3 years. Could be some suspended time in there. It wouldn't be a very different sentence. But my point is, if I were to sentence you any more severely than what Ms. Wood asked for on your behalf, today you could withdraw your plea. You could say, you know what? I was willing to take 2 years probation, 3 years, whatever it is. But Judge, you actually gave me weekends in jail, or you gave me 5 years probation. And that's not something I'm prepared to do. So no, thank you. And no one's offended. It's like it never happened. And we move your case on to trial. Today, you can do that if I sentence you to more than what Ms. Wood asked for. Do you understand that?
Yes, sir.
tomorrow or next month or on your trial date, and we will be calling that trial calendar on the 20th of September, you can enter a plea. If I sentence you to something you don't like, you just don't like it, and that's what happens. But you don't get to withdraw like you could today. That's one thing that changes. Do you understand that?
Yes, sir, I do understand.
Another thing that may change, I don't control it and you don't control it, is what the state's offer is. You may reach out to Ms. Wood next week saying, you know what, I talked to my commanding officer and the good Lord and anyone else you're talking to, say, I want to work this out. I want that 3 years probation. Ms. Willingham could say, too bad, so sad. That was the offer on July 7th, but I've had to do more, or I talked with the victim, and now the offer is 4 years probation. Now, Ms. Wood could still ask for 3 years, but the state is free to change its mind when you walk out of here today. Do you understand that?
Yes, sir.
Great. Understanding all those things, is it your preference, Mr. Price, to say no thanks today to the state's offer and have this case move towards trial in September?
Yes.
Okay. I want to be clear, that doesn't mean we still can't have this work out. And it sounds like that Ms. Wood has already come up with a different approach, maybe one that's more consistent with your plans to either join or stay in the military. And that may be how it works out. It may not, but it'll just be a slightly different setting when we meet again. It'll be in this courtroom. You'll just have a slightly different set of options. Okay?
Yes, sir.
Ms. Wood, anything else on behalf of Mr. Price?
No, Your Honor, thank you.
Ms. Willingham, anything else on behalf of the state?
Nothing from the state.
Okay, before you go, let me make sure I didn't just get something. No. Okay, we're good to go. So we will see you at the latest on September 20th. My hope is, if it's going to work out, we see you before then, because that's a long, messy day. And maybe that's when we take your plea. Bring lunch, because you'll be here for a while. If we sort it out earlier, you'll get a time that's a little more specific. All right, you are free to go if Ms. Wood doesn't need to talk to you more.
Thank you, Judge.
You're
I
welcome.
appreciate you. Thank you.
You're welcome.
Yes, ma'am. You too. Okay.
And that concludes my business for today. May I be excused?
Yes, so you are not handling any of the revocations?
No, Your Honor.
All right, thank you for joining us. I hope your time with family is going as well as it can.
Thank you.
All right, we'll see you sometime next week or later.
Yes.
All right, bye-bye.
Bye-bye.
Your Honor.
Mr. Hiles.
Hey, how are you?
Depends what you have to say.
Oh, I was just wondering if when we were gonna do the plea for Mr. Robinson.
Is that who's been like doing arm workouts in the background? Is that Mr. Robinson on the Samsung?
I believe so.
Okay, well, he's staying fit while he's waiting. We're doing it, it's an add-on to an already scheduled calendar, so I wasn't planning on cutting in front of folks.
Oh, that's fine.
But if the lawyers who are here say cutting is fine, that's fine with me. I just want to make sure we do have lawyers. I assume we still have back there Mr. Brown and Mr. Kemp. We don't have, I'm getting a scowl from your colleague.
Oh, Kim, yeah, Kim's better.
So that's only one. How about Brown? Brown's got 3 cases. We have both. Okay, we don't need to get them yet. Who is handling those for the defense? Both of those. And Mr. Peoples, are you handling the probation revocations?
Yes, Your Honor.
Okay, well then it's really who wants to arm wrestle whom. We can do the plea, and then folks doing the revocations will wait for us to do the plea.
I'm ready on the plea, Judge.
I'm not in a rush, Your Honor.
Okay, well, Mr. Hiles seems to be, because he's like, hey, what about me? So we'll do that. Ma'am, who are you here for?
Mr. Brown.
Okay, well, is it all right if we take a plea first?
No, we go ahead.
Okay, I don't normally ask anyway, so at least you had a voice in this one. You're welcome. All right, let's pivot then to the plea, and I did bring my trial calendar out here. So let's find that, James Robinson. Okay, let's get him spotlighted. Whoa, he's got like a zebra on him. And we'll add Mr. Hiles and Ms. Wood. All right, if you'd slide over a little bit.
Do something with the lighting in this courtroom, Judge.
You know, you could bring one of those little circle
literally
lamps
about to
that,
say.
yeah, I bet you there's a lawyer out there who does that. Wait, hold on. I need to look just right for YouTube. You've got a great fan base out there. Apparently this is a plea to an accusation.
Yes.
Okay, because I just heard that that's out there. I'm gonna look for it. I got it. Ms. Nelson is in motion. Oh, look at that. Reckless conduct. Okay. Someone must have a gang conference. Okay, let's figure out, Ms. Rivers, you ready to go?
Yes, I am.
Excellent. This is position 10 from our trial calendar, State versus James Robinson. We're actually moving forward on accusation 23 SC 188295, which is a permutation of 22 SC 184289, which I suspect will be null prost later on during our process today. Mr. Robinson, are you ready to go forward with a conversation about pleading guilty to the misdemeanor of reckless conduct?
Yes.
Yes. Okay, good. Mr. Robinson, you are wherever you are, which is not here in court, and that's fine. I need to make sure you are waiving your right to be here in court. Are you waiving your right to be here in open court? You might as well stay unmuted because the next 15 minutes are going to be lots of questions just for you.
Yes.
Okay. You also, along with having a right to be here in court, have a right to have Ms. Wood right next to you so you could ask her questions, pass her a note, etc. But you're choosing, where are you right now? Are you at home?
Yes.
Okay. You're choosing to be at home, which is okay. Do you waive your right to have Ms. Wood by your side during this plea conversation?
Yes.
Will you let me know if you need to speak with her in private? Because if you do, she can step outside and give you a call on that Samsung SMAO37U.
Yes.
Great. That's how we're going to handle it. Mr. Hiles, when you're ready.
All right. Yes, Your Honor. I went ahead and reaccused it. The reckless conduct was the underlying crime for the 2 gang charges, but it was not a lesser included. So I went ahead and reaccused.
Fine. Thank you.
Or accused. All right, Mr. Robinson, will you please raise your right hand? Do you swear or affirm the testimony you shall give in the matter currently before this case shall be the truth, the whole truth, and nothing but the truth?
Yes.
Will you please, you can put your hand down now. Will you please state your true, correct, and legal name?
James Robinson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
25, 10th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you were charged today in pleading to a single count of reckless conduct?
Yes.
Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney, Ms. Woods, about all the facts and circumstances known to you regarding the charge in this accusation, including potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
And Ms. Wood, do you waive formal reading of this accusation?
So waived.
And Ms. Wood, do you waive any and all defects in this accusation, including any with respect to your client's name?
We do.
All right. Mr. Robinson, have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Can you repeat that?
Have you been advised of the minimum and maximum for the charge that you are pleading to?
I think so.
All right, I'm going to go over it right now. So do you understand that for the 1 count of reckless conduct, you could be charged with up to 12 months or sentenced to up to 12 months incarceration and up to $1,000 fine? Do you understand?
Yes.
Do you understand that this is a negotiated plea of guilty, which means the state's making the recommended sentence to the court? The recommended a sentence of 12 months probation with a special conviction being no firearms during the course of that probation. However, the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run. It's a singular charge. Do you understand?
I thought it was a single charge.
It is a single charge. I was reading from something that I normally read for, but the court can sentence you up to the max of that single charge.
Right. Only one charge. Nothing is consecutive. The worst it could get for you would be 12 months in jail.
I understand.
All right. Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea? Do you understand?
Yes.
And do you understand that if you're placed on probation of any kind, you cannot possess a firearm as a special condition of your probation, and you cannot violate the laws of the state? Do you understand?
Yes.
Mr. Robinson, are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand?
Yes.
Do you understand that if you went to trial, you'd have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights?
Yes.
Do you understand you're giving up the right to trial by jury?
Yes.
Do you understand that you're giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that you're giving up the right to confront witnesses against you?
Yes.
Do you understand that you're giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that you're giving up the right to the presumption of innocence?
Say that again.
You're giving up the right to the presumption of innocence? Do you understand that? Do you understand that before entering a guilty plea or before this case would go to a jury, you are presumed innocent until pleading guilty? Do you understand that? Does that make sense?
Yes.
Okay. Do you understand that you're giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
And do you understand that you're giving up the right to appeal if convicted of this charge after a trial? Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and plead guilty because you are in fact guilty?
Can you repeat that?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yeah.
Okay. How do you plead to the singular charge of reckless conduct and accusation 23 SC 188295?
Can you repeat that?
How do you plead to the singular charge of reckless conduct and accusation 23 SC 188295?
Yeah.
So it's not a yes or a no. It's you plead guilty or not guilty. Those are usually the two options.
I plead guilty.
Okay.
Somebody's knocking at the door, so I can't really understand you.
Okay, I'll try to speak up. Is this guilty plea given freely and voluntarily and with full knowledge of the charge against you?
Yes.
And do you understand you have only a limited right to appeal this guilty plea conviction?
I got exactly who?
You have a limited right to appeal this guilty plea conviction.
Yes.
Do you understand that you have 12 months from today's date to file a habeas corpus petition challenging the voluntariness and the constitutionality of this guilty plea? Do you understand?
Yes.
Okay. Your Honor, were this to go to trial, the facts would show that on July 28th of 2022, investigator J.P. Miller of the Fulton County DA's office and investigators Starks of the Atlanta Police Department gang unit were doing a targeted sweep of the Newtown Circle apartment complex at 917 Newtown Circle in front of building 910. The two investigators were parked directly across the street at the Exxon at 840 McDonough Boulevard. While they were observing activities at this particular apartment complex, they observed Mr. Robinson talking with several other individuals. They observed multiple cars pull up and several hand-to-hand transactions. And they also observed Mr. Robinson pointing a pistol at multiple passing cars from the tree that he was standing next to in front of the apartment complex. Upon witnessing this, officers, the investigators called for marked patrol units. When the marked patrol units came in, the silver Toyota that was conversing with two occupants that was conversing when Mr. Robinson fled. That car was chased by the Phoenix helicopter, which ultimately had to abandon the chase because the car drove into what was Hartsfield Airport airspace. And the officer Fife was able to get Mr. Robinson in custody. Next to the tree that he was standing in was a Glock G45 9x19 handgun with an extended magazine. Mr. Robinson told officers on scene that he had the gun in his waistband, that he actually pulled the gun out of his waistband for safety when an unknown vehicle approached his area. A search warrant was done for his phone. He did have several posts and screenshot in his phone talking about his membership with the Glock block grips, as well as tattoos that were indicating his membership in the criminal street gang. Your Honor, we have come to the resolution of the underlying reckless conduct charge. And upon if you accept this guilty plea, would be moving to null pros the original indictment of 22 SC 184289.
Okay. And other than no firearms, any other conditions of the 12 months of probation? Hold on, Mr. Robinson. I'm going to hear from you and I'm going to hear from your lawyer.
No, Your Honor, it's no possession of firearms is the only condition.
Okay. All right. And Mr. Robinson, I've muted you again, not because I don't want to hear from you. I promise I want to hear from you, but your house has some funky noise in the background. And so it's harder to hear others when you're muted. You don't have to fuss at anyone. It's just when it's your turn to talk, you can unmute. But for now, it'd be best if you didn't leave. All right. Why don't you stay there and we'll figure it out. Okay. Mr. Robinson, why don't you ask your question and there'll be time. You and I are going to have a conversation. I'm about to ask someone else some questions, but you had raised your hand. Is there anything you want to ask at this point?
I'll just wait my turn.
Excellent. Keep in mind whatever it was you wanted to say. Ms. Tyson, could you share with me, please, any criminal history information you have for Mr. Robinson?
Yes. Mr. Robinson, he has 5 arrest cycles beginning in 2016. He has no felony convictions. His last arrest, and I don't have a calendar, so please apologize. I apologize.
Oh, I'm sorry. That's right. He's not. He's
repetitive.
yeah, he's from our trial calendar.
Okay, so the last arrest that I have on his GCIC was from July of 2022 for aggravated assault, strangulation. So I'm not sure if that's, I don't know if that's on the calendar or not. I don't know.
No,
That's the last arrest on his GCIC, and there is no disposition listed for that case. And I don't see anything in Odyssey either. So I don't know if it's under, I don't know, another name, or maybe the ADA can speak to that. But I don't see a disposition for that listed on GCIC. And the one FTA is out of Atlanta. Underlying charge is robbery by sudden snatch. And I don't see a disposition for that case. It gives the case number, but the case number that was entered into the GCIC is incorrect.
Okay, well, that's not helpful.
Right, it wasn't helpful. I couldn't find it.
No, and I'm sure if we put James Robinson in Odyssey, it comes up with 30,000 records. So that's not going to help a lot either. Okay. Mr. Hiles, did you have anything different in terms of criminal history for Mr. Robinson?
No, Your Honor, I think that's correct. I know that ag assault arrest went to the DV unit, and they have not made a decision on whether or not they're going to go forward or not.
Okay. But presumably Mr. Robinson is on bond for that?
Yes, he is.
All right. All right. Ms. Wood, what do you want to share?
Thank you, Judge. Mr. Robinson is 25 years old. He's a lifelong Atlanta resident. He did attend Carver High School through the 10th grade. He has 2 children. He has worked gainfully as a forklift operator at the Walmart warehouse. Judge, at the time of this incident, as he is not a convicted felon, he legally owned the gun. He carried the gun as a form of self-protection. It was a high crime area. We appreciate Mr. House's willingness to work with us on this case, and we just ask that this court accept the state's recommendation.
Okay. Mr. Robinson, your turn. You can ask questions. You can give a speech. You can say, let's get on with it.
Okay. First off, I have a question. She said I never said I had a gun on my waist. And I was standing on the right side of the tree. The video that the officer said he got something with no gun, none of that. I'm standing on the right side of the tree. They got it done from all the way on the left side of the tree. I was outside of the gate when they locked me up. I was on the ground. I ain't do no extra, no running, no nothing.
Okay.
I was just reading the report.
Now I'm just speaking on my behalf.
I know. No. Don't worry. Mr. Hiles had his chance, and now you're speaking on your behalf. I said you could do that, so I'm listening. Anything more you want to say?
I don't know what type of, they saying like a hand disagreement. It was a straight one of these. It wasn't none of all the hand movement. They trying to make it seem like it wasn't none of that. I never had no gun on me to wave a gun. I never got with the guns, and I thought this reckless. I'm not arguing with it because I went on with my decision. I'm just saying I already thought that it dropped the reckless conduct.
So this last part, I understand partly you're saying, let me tell you what really happened, because you were there and we weren't. And officers may need to get a little more training if they're confusing dapping with the hand-to-hand transaction. So, but tell me, you seem confused about, you first started to say aggravated assault and then reckless conduct. I want to make sure.
I'm talking about I meant the reckless conduct. I just couldn't get it out. Reckless conduct, what I was charged with. I thought that had got dropped.
So it may have been dropped originally, but what you got indicted for was a much more serious felony because it got linked with gang stuff. And the state has now walked back from that, and they just said, you know what, let's just call it reckless conduct. And that's it. So that's the misdemeanor that you'd be pleading to if we go forward.
Okay, that's fine. And another thing is, how did I have a gang charge when I wasn't booked with a gang charge?
So you could be booked for marijuana and later on charged with murder. What you get booked for doesn't necessarily correspond with what you get indicted for. The state may learn more, they may learn less, they may add charges, they drop charges, they can present to the grand jury whatever they think the evidence supports. So you're right, you were not booked on a gang charge. But then the district attorney's office got together with gang investigators, and you heard what Mr. Hiles had to say. They had their theory of the case. They've walked back from that now and said, you know what, we're just going to call this reckless conduct. But you shouldn't be surprised that you get booked for A and indicted for B.
It was confusing because I'm getting booked on a regular conduct, have nothing to do with no gang charge, and I'm through with that. And I got another thing is why are they going to my phone off of reckless conduct? If you're accused of reckless, if you see the video, if any one of y'all see the video, you know the video, you don't see me waving no now firearm. You see me standing right there with some headphones in my ear.
So here's where we are, Mr. Robinson. You are free to give me your version of events. I need to know if you want to go forward with a plea, because if you don't, then
I'm going forward with the plea regardless. I'm just giving you my side of the story for how y'all how the police will make you try to look bad, like make me look bad. Like that's what I'm trying to clear up. I'm going on with the plea just
okay. All right, I want to make sure you're comfortable. I'm going to make this actually a slightly different plea now. I'm going to make it what's called an offered plea, where you are saying, I think it's in my best interest to plead, but I'm not agreeing with what the state said.
correct.
Correct. I got one thing right. Good. So that's what this is going to be, is an offered plea. So Mr. Robinson, you understand that you are able to take an offered plea where you say, look, this is, I want to resolve this, and this misdemeanor, that's worth it. I will do it for that. But I'm not admitting that I was standing there at the tree, waving this gun, pointing it with an extended mag, et cetera. But I still want to work this case out. Does that describe your situation?
Yes, like I just want to. I don't want to be looking like on my behalf, like I'm just this type of criminal, this type of gang. Like that's all I'm trying to present on my behalf. The state try to make you look great. I'm trying to do on my behalf.
Got it. I understand how you are trying to set the record straight from your perspective. And clearly the officers saw it a different way. And if there was a trial, the jury would need to decide which perspective do they go with. But that's not where you want to go with this. You don't want to go to trial on felonies. You want to take this misdemeanor plea. Is that correct?
Yes, I'm just going to take the plea to go and get going so I can be through with it.
Okay. You understand you don't have to do that. You're choosing to do that. Is that right?
I'm doing it at my own will. Yes.
Got it. Okay. Then I'm going to accept your plea, Mr. Robinson. I find there is a factual basis, meaning if the jury credited the investigators and the officers' testimony, they could find you guilty. You've helped me understand why there's probably some evidence in the other direction as well. I also find that your plea is knowing, meaning you've understood things. You are very articulate, and it is clear to me you understand what's going on. I also find that your plea is voluntary. You are voluntarily, meaning of your own free will, deciding to go forward with this offered plea because that's how you want to resolve this rather than wait around for a felony trial. Is that correct?
Correct.
Okay, I'm going to accept your plea. I will sentence you, as has been negotiated, to 12 months misdemeanor probation. And the only condition of that probation is that you not have a gun while you're on that probation. I will waive your probation supervision fees for the first 3 months. And that is it. Mr. Hiles, will you authorize my team to sign the accusation in Mr. Robinson's case?
I will.
Ms. Wood, can we sign for you? Yes, please. And Mr. Robinson, can we sign for you indicating your offered plea to the misdemeanor?
Yes.
Yes?
Yes.
Great. Okay. And Mr. Hiles, now that the plea has gone through, are you moving to null pros or dismiss the original indictment?
Yes, Your Honor.
We will take care of that. Ms. Wood, will you get the misdemeanor probation reporting instructions to Mr. Robinson when you get them?
Absolutely, Judge.
All right. I think that's it. Don't go yet, Mr. Robinson. I need to check to make sure my boss hasn't sent any other directions. Nope. We're good. Do you have any other questions, Mr. Robinson?
Where do I go take this off immediately?
Would that be a lovely picture of your leg and the ankle monitor?
Yes.
All right, I don't need to see that anymore. That's a good question. Uh-oh, Mr. Hines.
I'm not, is that for this case or is it for the ag assault?
This ankle monitor for that case, what you just dismissed, what you just.
All right. Well,
Well, I need the CP number of the other case.
Yes, Judge, it's 22 CP 211039, I believe.
211039.
So.
James Robinson. Bond order in July. Stay away from Jaquana Ferguson and an address on Maury Avenue and no weapons. You got a lot of people telling you not to have a Glock 9x19 or whatever that was. But it doesn't say anything about ankle monitor. Let's look at the bond in this case. 4289. I don't have a bond. It didn't get linked to this case.
Your Honor, when I went to first appear, when I got an extra charge, when I got them 2 gang charge, extra charge, I went to court. I went back to court. They gave me a bond and gave me ankle monitors.
I'm not doubting you, Mr. Robinson. I just wanted to make extra sure, because if we send you to get that thing taken off and we're wrong, they're going to think you are trying to commit another crime. That's all. So I'm just looking for your bond.
Judge, I think it's the CP case bond from July 30th, 2022.
What CP's case is that?
The 211039.
The one we just were talking about?
Judge Rashida Oliver.
I got a Raquel Pope setting bond at 15 grand in the one that ends in 039.
So there's another additional bond order on that case
Okay.
by Judge Oliver.
Well, let me go back to that.
It's right above the first appearance entry.
Oh, there's the next day.
Yes.
The next day. So docket 5, if we use the new feature in Odyssey, ankle monitor paid for by the county. Yeah. So Mr. Robinson, the ankle monitor is associated with your case involving Ms. Ferguson. So that doesn't mean you can't get it off, but you're going to need to talk with your lawyer in that case.
Listen, Your Honor. I got a bond for her. I didn't have no ankle monitors for her. I had to go back down.
I'm happy to talk to you about this.
Court date. To get up because I was booked because they got gang charge on me at 11 o'clock at night. So I had to go Saturday morning to court. That's when they gave me the ankle monitor. I didn't have no ankle monitor for that.
Okay, so try this. I know you're on a phone. Can you see on your phone, if you magnify, what I just put up on the screen? Can you see what it says in red?
Yeah, I see an ankle monitor to be paid for by the county. They gave me a gang charge. I did not get this ankle monitor. I got a bond for that for what I had a warrant for. I got a bond for that.
I know. Hey, you know what? I need you to take a deep breath and stop yelling. That bond that you're looking at right now is for 3 counts. The 2 gang counts and the aggravated assault that is the Ms. Ferguson case. Now, you had a bond the day before for Ms. Ferguson with no ankle monitor. So I think we can ditch the ankle monitor. I don't have a problem with that, but you're still on bond for that aggravated assault. And so I would need to enter an order that modifies the bond, and then you'd be removing your ankle monitor for a different reason, not because of this plea, because we got rid of those gang charges. But it's technically right now a condition of bond also for the aggravated assault. And that's what's on the screen. And you can dislike it, but it doesn't change it that you dislike it. Okay? Mr. Hiles, do you have any objection to removing the ankle monitor requirement? Because it sure does look like that came up after a different judge had set a bond solely for the aggravated assault.
I don't have any problem removing the ankle monitor so long as all the other no contact provisions stay in place.
Right. Okay. So we'll modify that. It's not going to happen today.
Yes, Judge.
You have a way of reaching Mr. Robinson?
I do.
All right. So Mr. Robinson, you're going to get two different messages from Ms. Wood. One of them is going to be about probation and where you need to report and when. And the other will be an update as to when I was able to modify your bond so you don't have to wear that piece of hardware. Okay?
Yeah.
Thank you would be okay also. All right, that's it. You will get something from Ms. Wood, and stay away from trees with guns sticking out of them, okay?
You're free to go, Mr. Robinson.
All right, Mr. Hiles, thank you. Enjoy your conference.
All right, thank you, Judge.
You bet.
What about my phones?
What are we complaining about now, Mr. Robinson?
Judge, I explained.
What about my phone?
Your phone?
I'm saying, can I go to Donna Lee and get my two phones?
I will send you the final disposition, Mr. Robinson, and you can take it to get it out of evidence.
You can. Once you get that final disposition, they should give it back to you. Anything else we can do for you today?
No, that's it.
Thank you, Judge.
All right, he's gone. You're welcome. All right, let's do our case with Mr. Brown. That took a long time. Please.
Yeah, Judge, I almost regret saying I wasn't in a rush.
Yeah. Well, wherever we all hope to be at 3 on a Friday, we now know the answer. It's 8D.
Yeah.
Okay.
Do you want me to do both of them? Okay. But if you don't want.
Yeah, no, that's fine. Oh, I have your charger.
Yeah, but you're open. Locked and loaded. You want to set the podium?
It depends how long it's going to be. We didn't talk about how it's going to play out.
It is going to be admission for probation purposes with explanation and mitigation.
Okay, so why don't we just sit? It'll be easier since everyone else is virtual.
We're not a Mr. Robinson level.
It's probably good for everyone. Give me 1 second. All right, I just need to get the warrants up. So let's go on the record in Mr. Brown's 3 cases. He has an indictment from 2015 and 2 from 2016. And we have Mr. Brown in court. Hello, Mr. Brown.
Hey, how you doing, Your Honor?
All right, how are you doing?
I'm doing all right, sir.
All right, Mr. Brown is here in court with Ms. Feely, and we have Mr. Peoples online for the state. And in about a month, 2 months ago, in May of this year, I signed warrants that alleged that in July of 2022, so a year ago, you committed battery in Clayton County. That was the basis for the warrant and a possible revocation. So Ms. Feely, you said that for the purposes of our hearing today, you were going to, well, through you, Mr. Brown was going to stipulate that he was arrested for battery, and maybe since it's a year ago, it's even been resolved. So why don't you share with me the situation and how Mr. Brown is proposing we deal with it? Then I'll hear from Mr. Peoples and from Officer Tucson. And let me do this one last thing. Ms. Tyson, you are free to go. We're not taking any pleas. The Kemp and Brown are just revocations. Is that correct? Great. Thank you, Ms. Tyson, for being with us on a Friday.
Thank you. You're welcome.
All right. So Ms. Feely.
Thank you, Your Honor. Mr. Brown sits before you. He's 45 years old. He went to the 11th grade at Southside High School. His girlfriend has been here, as you've seen, Sybil. He lives with her and their blended family. They have several children. They met working at the airport. He was working stainless steel plates, like at the escalators and stuff, and she also was working a cleaning job. But the most striking fact about Mr. Brown is he got out of prison in 2019 and has had no other blips until this July 2022 arrest. And it's my understanding it is still pending. It's not a family violence battery. It's a battery. It doesn't involve Miss Sybil or anything like that. So he has gotten back on his feet successfully for so long now. And this is my understanding. I understand it's 3 cases, so it doesn't look great. And
But they're old.
They are old.
When you say he got out of prison in 2019, he was serving time for some collection of these cases?
He got a 10-3 on all 3 of these.
Okay. In 2016, did 3 years, got out in 2019, or whenever he pled to these cases, served the custodial portion and has been on probation since. And we'll hear from Ms. Tucson, but the primary hiccup would have been why we're here today, because of an arrest in Clayton County in July of 2022.
That's my understanding. Yes, Your Honor.
Okay.
So based on all of that, we are hoping that Mr. Brown can keep his job at the airport and go back to his family and children. And so we're asking the court to consider the 37 days that he served. And we're asking that you sentence him to 30 days and reinstate.
All right. Ms. Tucson, how much time is left on these 3 cases?
They both have the same remaining time, all 3 of them. There's 3 years, 1 month, and 14 days remaining on these cases for probation.
Got it. And how has Mr. Brown done since he's been under DCS supervision?
I don't see any other warrants besides these that were just uploaded, not too long ago. And there's no record of any revocations. So that's just these.
Got it. Mr. Brown, how long have you been working at the airport?
I was there probably about 5 or 6 months.
Until you got arrested here?
Yes.
Okay. What were you doing for work before? Because you got out in 2019. So
I've been working numerous jobs.
Okay.
I'm trying to stay out of trouble because I know my criminal history will, you know what I'm saying, jeopardize my freedom.
It might. That's right. Getting in trouble again would be a real bad development. What is the status, if you know, of the Clayton case? The charge is just out there? You haven't heard anything more?
No, sir.
Okay. Is the person who's allegedly involved with that a stranger or someone you know?
Someone I don't know.
Okay. So is the job that you had at the airport the job you've had the longest of the different jobs you had since you got out?
I was working at, the longest job I had, I was working at, CKS on Fulton Industrial. It's a
I know it.
plastic company.
Yeah, the packaging company.
Yeah, I worked there for 2 years
Why'd you stop?
because, like my pay, like I moved up from a packer to a lead, from a lead to utility, from a utility to a machine operator. So they wouldn't never like escalate my pay.
Oh, so they're giving you more responsibility, but not more pay.
Yes, sir.
All right, so you left because you felt you could get a better deal or better recognition elsewhere.
Yes.
Okay. Well, that's frustrating. I've had folks I know work their way up, and generally they paid them a little bit more for each thing, but maybe that's changed.
And I had been working there ever since, like I was making like $13 an hour, and I worked my way up from 13 to 15. So as I moved up in the company, they would never pay me.
Yeah. Okay. Does the job at the airport pay better than that?
It's basically like the same, but the work is not much as hard as it is.
Okay. And when you get out, you have a place to stay?
Yes, sir.
Okay. Is it a house or an apartment?
It's basically like a house.
When you say it's like a house?
Yeah, it's like a town.
Okay. All right. Mr. Peoples, what is the state's recommendation in this case?
Your Honor, the state's recommendation would have been 90 days and revoke 90 days and return to probation.
Okay. So I guess the delay here, there's just a funky delay. It's really the warrant didn't come for a while, the probation warrant, because this incident was in July of last year, but I didn't get a warrant to sign until May of this year. And then the warrant fairly quickly caught up with Mr. Brown. How did you get arrested, or where did you get arrested 37 days ago or whenever it was?
I was at my girl's house, and a situation happened at her house, and they ran my name and I got locked up.
Would your girl be the woman who's here in court?
Yes, sir.
Would you call her? That's what you call her, is my girl?
Oh, I ain't gonna say my girl. It's I want her to be my wife though.
Okay, that's a big statement.
She's been there for me. I'm being honest, she has.
Okay, but something happened there. Police come, they run your name, and there was a warrant.
Yes.
Got it. Did you get arrested for anything else that night, or just because of the warrant?
Just because of the warrant.
All right. Okay. All right, Mr. Brown. Well, I find myself not exactly in the middle, but a little bit in between what Ms. Feely is suggesting and what Mr. Peoples has suggested. I think I understand both perspectives. Working in your favor is that you seem to have done pretty well since you got out. Life is complicated with your criminal history. It's extra complicated. It's not easy to get a job. It's great that you had that job for a couple weeks. Couple years at CKS. I understand why you moved on from there. But I don't know what happened in Clayton County, and you're going to need to avoid situations like that. I'm sure there's another side to it besides you getting arrested for battery, and maybe the other guy got arrested, or gal, or whoever it was. But you just need to walk away from situations where you might get arrested. And so, as another example, you got arrested 37 days ago because there was something that happened at your household. Whatever that kind of something is, you need to figure out a way to say, you know what, I'm going to be back in 2 hours because I'm about to do something that's going to cause someone to call 911. And the chips are usually not going to fall in your favor when the police show up. It's like, oh man, that's Detrick Brown, criminal history, this, criminal yada, yada. And then you get locked up. And you may be thinking like, hey, I understand I got in a scrap, but really that guy was bigger, or he hit me first, or she started. It's rarely going to end where they're like, you're right. You know what? Not right now. That's going to end up in your favor at that moment. And then you get arrested and you're on probation, and then you got to sit around for 2 months. I get it that you're trying. You just need to be extra careful while you're on probation, not to get into situations. What I'm going to do, Mr. Brown, is revoke 45 days of your probation. You'll get credit for all the time you've been in. And I will reinstate the balance. You got the same on all of them. So you got about 3 years left. If you do well for the next couple of years, I encourage you to reach out to, you're going to have contact information from Ms. Feely. And even if Ms. Feely gets promoted and is somewhere else, you could reach out to the public defender's office and say, look, man, I've done well for a couple of years. Maybe we could close all this out. I'm all for early termination of probation if things are going well. Right now would not be the right time to ask. But if you get a couple of years under your belt, and things are going smoothly, then you should do that, okay?
Yes, Your Honor.
Got any questions?
Oh, sir.
All right. Ms. Feely, anything else?
No, Your Honor, thank you.
Mr. Peoples, anything else?
No, Your Honor.
All right, thank you.
Just make sure you report when you're released from custody.
Oh, that's right. Before you disappear,
Brown.
Mr. Brown, your address, is that in Fulton County? DeKalb. So when you were reporting to probation, were you coming here downtown or way out to Conyers? Okay, is that all right, Ms.
Yeah.
Tucson, if he reports in Fulton?
I have an address that states it's 415 Griffin Street Northwest.
He has a new address now.
May I have the address?
Yeah, can you get near a microphone
number?
and let us know what that address is, please?
I don't know the address by heart.
I think someone knows it. If you'd stand up and project, what is the address for Mr. Brown?
It's 3910 Wall Drop. That's wall with one L, wall, and then drop, like you drop the pen, one word. 3910 Wall Drop Lane, Decatur, Georgia, 30034.
30034?
Yes, ma'am.
Okay, and is there a good contact number for you, Mr. Brown?
Am I supposed to be?
Yeah, do you have?
I have two numbers, actually, if I can give you both.
One phone number is good, and then I'll give you a call because depending upon when he gets out, he'll either have his case transferred or he'll report here and get it transferred. One phone number is good.
Okay, you can do 770-292-8489.
Okay, I'm going to repeat that back. 3910 Waldrop Lane, Decatur, Georgia, 30034. 770-292-8489 is the phone number.
Yes, ma'am.
Okay, and just make sure, Mr. Brown, when you are released from custody, you report within 48 hours of release, okay?
Yes, ma'am.
All right.
Yes, I'll be on probation.
Thank you. We're ready for Mr. Kemp when you guys are. Thank you for being here.
No problem, thank you.
I mean, I think you can read my handwriting. Most stuff got dismissed. Okay, hold on.
So these look pretty technical, Mr. Kemp's violations,
Like,
as in not new charges.
so he had new arrests,
Oh,
but.
well, okay.
They-
Let's get him out here and on the record.
And I think, believe Ms. Wood is gonna handle it.
Yes.
Oh, look at that. All right, our last case of the day. It is State versus Santarius Kemp, 15 SC 134995. Mr. Kemp is here in court with Ms. Wood. He is here for a probation revocation hearing. We have Mr. Peoples online representing the state. And Mr. Kemp, it is alleged in the warrant that I signed over a year ago, June of 2022, that Mr. Kemp had effectively absconded. There was an address of record, and probation went out there. People who lived there said, there's no Mr. Kemp. In May of last year, Mr. Kemp was told to show up and bring proof of wherever your new residence is, and Mr. Kemp decided not to show up. So it's an absconding situation. There may be another variable at play, but that's what I've got on my warrant. Do you have a different warrant, Ms. Wood?
No, Judge, I think I'm basing off the booking screen. So I do have that warrant. I just noticed there were some new charges as well.
Okay. We can talk about those. Technically, there's not notice to you and Mr. Kemp that we would be talking about those. But if you and Mr. Peoples have looked at Mr. Kemp's situation through the lens of, yeah, you absconded, and by the way, there are new charges, I'm happy to hear those.
I don't know if Mr. Peoples and Ms. Feely had a chance to talk about that, but I did want to.
What is the CP number or the booking number, whatever's easier?
Judge, it's probably easier the booking number because it looks like they might have combined CP numbers. So the booking number is 221-1479.
Wow, that's still he's been in since then? That's the booking number? That's okay. All right. Let me look up a booking number. There he is. Entering auto. Oh, there's an SC. There's a new indictment.
It looks like well, I'm not sure if they combined.
The warrant it says entering auto, and then it's got an old case, this case, which are some theft by receiving and whatnot, but there's a new indictment number. Let's look.
Okay, so it looks like they combined some CPs because there are no open CPs at this time, Judge.
Yeah. Here's Mr. Kemp. It's a non-complex case with a whole lot of entering autos, but it was indicted just a few weeks ago. And it combines a couple CPs, but none of that is on the probation warrant. So we can talk about it if you want to talk about it. I've got Mr. Kemp here for the technical violation of he took off. Let me do this because this may change everything we do. How much time, Ms. Tucson, remains on this 15 SC case?
For this particular case, because he's on probation for 3 cases, 3 counties. So for Fulton, he has 1 year, 8 months, and 25 days remaining on this case.
Got it. And he may have more or less probation out of other jurisdictions, but the one case I can do something about today, he's got a almost 1 year and 9 months.
Yes.
Okay.
The cabin Gwinnett, it's longer time.
Longer time. Okay. And are they looking for him?
I don't see.
There are holds, Judge.
There are holds from both counties? Okay, so.
I'm double checking.
And I've got Mr. Kemp having been in for almost a year. Okay, why don't you tell me what you want to do? I've got a thought about how we could wrap this one up, but you tell me your thoughts.
Judge, I would recommend revoke 1 year and close the case out since he's got some other matters hanging around.
Read my mind.
He's 28. He has 5 children. He has an 11th grade education. He was gainfully employed at Sherwood Food Distribution. It's a warehouse for the past 5 years. I did provide an updated address to Ms. Tucson, and yeah, we would ask that you accept our recommendation.
Okay. Mr. Kemp, what did you do at Sherwood Foods?
I loaded trucks, wrapped pallets, just like stocking, loading.
Okay. Does that mean you were actually operating like a forklift or something?
A pallet jack.
A pallet jack? You were there for 5 years?
Yes, almost.
Okay, but I mean, you were there for a number of years.
I will.
Okay, and did you stop working there because you got arrested, or you had left there and then something else happened?
Yes, I got arrested.
You got arrested. Okay, all right. What kind of cases do you have out of those other counties?
I have probation.
Okay, but for what were you on probation?
I'm on probation for Gwinnett, for inner auto. The cab, it was possession of firearm, but it should be about up.
Okay. Well, Ms. Tucson was saying it might be a little longer there than it is here.
It's longer for Gwinnett, definitely.
Okay. Let me look here. Your indictment here, which has 14 counts. It is all from 2022. So it's older conduct that just got indicted. It's February, March, April. It's all entering autos. And you will be going to court on that in August, non-complex. Okay. Mr. Peoples, what are your thoughts about Mr. Kemp's situation?
Your Honor, the state would concur.
All right. Mr. Kemp, anything you want to share with me?
No, Your Honor.
You've been stuck for a while. You're wearing orange. Does that mean you're being housed up in Cobb?
Yes, Your Honor.
Okay. Is that where one of your holds is, or it's Gwinnett?
Yes, it is Cobb.
Okay. That should make it easy for them to get you. All right. What I'm going to do is revoke 1 year of your probation. In this case, you'll get credit for the time you served, and I will suspend the balance of your probation. You'll probably stay here for a little while just because of that plain arraignment coming up, but don't take my word for it. It may be that Gwinnett gets a call and on Monday you're on your way to Gwinnett, but you've got a couple other jurisdictions where you need to clear up whatever you're going to clear up there. And then ultimately you'll need to come back here. I can't tell if you have a bond that you have a bond in connection with some of these entering autos, but I don't know how the sheriff's office would treat that bond. It's $24,000 bond, but it's not for all the counts. So I don't know if you made that you'd get out. I also don't know what Cobb and Gwinnett are going to do, but a lawyer can help you with that. Any questions about anything, Mr. Kemp?
No, Your Honor. Thank you very much.
Okay. Ms. Wood, anything else?
No, Your Honor, thank you.
Mr. Peoples?
No, Your Honor.
All right. Ms. Tucson, do you need anything more from me in connection with Mr. Kemp's case?
No, Judge.
All right.
I'll send the order over.
Great. Thank you so much. I think that takes care of everything. Mr. Peoples, anything else?
No, Your Honor.